5 seconds to go. Start. Appeal will be considered and decided on merits, and therefore no prejudice would be caused to the appellant. It is submitted that in order to enable the respondent's appellants before the High Court to submit the case on merits instead of non-suiting them on the technical ground of delay, it is prayed to dismiss the present appeal. We have heard the learned counsel appearing on behalf of the respective parties at length. At the outset, it is noted that by the impugned order, the High Court has condoned a huge delay of 1011 days in preferring the second appeal by respondent numbers 1 and 2, herein original defendants appellants before the High Court. While condoning the delay, the High Court has observed as under. In these circumstances, when there are certain questions which require a debate in the second appeal, it is not necessary that this matter be rejected at this stage without inviting a decision on merits. If the delay is condoned, though enormous, what happens at best is to give an opportunity to the parties to canvass their respective case. Since this question being of procedure, the attempt of the court should be to encourage a healthy discussion on merits than rejecting at threshold. Viewed from such perspective, accepting the reasons assigned by the petitioner, the delay in presenting this second appeal should be condoned. Apparently, there is no willful negligence on the part of the petitioners, nor this attempt suffers from want of due diligence. It appears being a bona fide attempt on the part of the petitioners to canvass their claim, particularly when the trial court had accepted their plea, which was subjected to reversal by the appellate court. However, the petitioners should compensate the respondent by means of costs for this delay. The contention of the respondent that valuable rights are accrued to her on account of inaction of the petitioners in failing to prefer the second appeal within time cannot be a significant factor in the backdrop of the circumstances found in this case. In the result, this petition is allowed condoning the delay of 1011 days in filing the second appeal subject to payment of costs of rupees 2000 only to the learned counsel for the respondent on or before 5th October 2021. Thus, from the aforesaid, it can be seen that the High Court has not observed that any sufficient cause explaining the huge delay of 1011 days has been made out. The High Court has observed that if the delay is condoned, no prejudice will be caused to the appellant as the appeal would be heard on merits. The High Court has also observed that there is no willful negligence on the part of the respondents herein, nor it suffers from want of due diligence. Stop.